Everybody needs to have that experience on the board.
You can go ahead.
Order. Today's meeting of the Municipal Code Enforcement Board is called to order on November 19th, 2025. Please rise for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Please be seated. Agendas of today's meeting are on the wall at the entrance to chambers. Please remember to turn off your cell phones. The Municipal Code Enforcement Board consists of 7 members who are appointed by the City Council. We serve voluntarily. It is this board's intention to promote, protect, and improve the health, safety, and welfare of the citizens of Clearwater by providing this equitable, effective, and inexpensive method of enforcing certain codes within the city. The board considers new business items in 2 parts. First, the violation, and then affirmative relief. Formal rules of evidence do not apply. Each side is limited to 15 minutes. The board may grant additional time. All proceedings will be conducted in a calm, civil manner. Individuals who conduct themselves otherwise will be asked to leave. If necessary, you will be escorted from the chambers. Now I ask all who plan to speak to rise and be sworn in by our clerk.
Do you swear or affirm to tell the truth throughout your entire testimony? I do. Thank you.
Our first order of business is to review and approve the minutes of last month's meeting. May I have a motion to approve the minutes?
I have a motion to approve the minutes.
I have a second?
Second.
All in favor? Aye. All opposed? The minutes are approved. The next is new items on our new business items. 3.1 on our agenda has been withdrawn. 3.2 on the agenda is continued from October 22nd, 2025. Find respondents Tego Ankar and Storm Alencar at 917 Pinellas Street in violation of code for short-term rental and issue an order with a compliance deadline and fine if compliance is not met. Is there anyone here to speak on that? Will you please step forward to the microphone, please? Good afternoon. Will you state your name and address to the clerk, please?
My name is Thiago Alencar, 917 Pinellas Street, Clearwater.
Storm Alencar, 917 Pinellas Street, Clearwater, Florida.
Good afternoon. Do you guys admit or deny the violation? Admit to it?
Yeah.
Okay. Can I have a first motion, please?
I move to find the respondent in violation of the code as referred to in the affidavit in this case.
Second.
All in favor?
Aye.
All opposed? Motion approved. If you'll have a seat right there, I'm going to let the city come up. Thank you.
All right.
Inspector, you have the floor.
Good afternoon, Board. John Stevens, Code Compliance Inspector for the City of Clearwater. Again, this is case number 125-25 for 917 Pinellas Street. This is actually a repeat violation case for short-term rental, or excuse me, illegal short-term rental. The notice of violation was mailed out on June 10th of this year, and we received it back in the office, returned to sender on June 25th, so I went out on June 26th and actually posted the property. And this is a picture of the property here itself, and you can see up here next to the door, that's my posting of that notice. This property was previously found in violation by the Municipal Code Enforcement Board on December 18th of 2024. And this is the order from that date, basically finding them and telling them that they had to stop the short-term rental. And then this is actually the picture from the initial violation that started this whole case back in May of 2024. Just to show you that on that date, you could actually run it for 1 day. So they were in violation of the code at that point. This is also where they obtained their business tax receipt afterwards, and there is information on there that obviously informs them about what we define as a short-term rental and the initial that they will not, basically partake in doing short-term rentals. The next slide here is actually on June the 10th of this year when I found the property again on Airbnb. You can see here where I have highlighted that I was able to select it for a 2-night minimum stay. This is on June 26th when I had to go back out there and post the property after receiving the mail back. Again, I could select it for a 2-night minimum. And then this was on July 25th. It was still set as a 2-night minimum. I ended up finally getting a hold of Mr. Alan Carr. Apparently, they actually live in a different state right now. His wife was going to school. There were some issues. They weren't getting notices and things of that nature. So they were able to get everything taken care of now. So as of, 9/29 is when I actually got a hold of them. So excuse me on that last section there, because it was still set to 2 nights there. But I was able to get a hold of them. We got everything worked out, and as of yesterday's date, it is set for the minimum 31 days now, as required by our code. So compliance can be met for an illegal short-term rental is by basically changing any rental listing on any website or platform, such as Airbnb, VRBO, Booking.com, et cetera, to a minimum of 31 days, which they've done. So they've basically brought that into compliance now, but with this being a repeat violation, they were already in, violation. So since they now fixed that part of it, we're gonna ask for the one-time fine is our recommendation of a $500 fine. And I've had conversations with both Mr. and Mrs. Allen Carr that should this occur again, then this is gonna become a recurring fine. And they understand can't think of what word I want to use right now, but all the circumstances around that will qualify as that.
Inspector, were they in violation during the month of October?
I believe so.
You contacted them on September 29th, but did they continue through October? So,
It was actually October, like I said, I misspoke on the
Oh.
September thing. I got a hold of them in October.
October, okay.
So,
thank you.
Board, do you have any other questions for Inspector?
None at the moment.
No? All right, Inspector. Mr. Stallincard, you can up, please. How did you guys get back into non-compliance after you had already been before our board the first time?
I understand that. Actually, that was like on me. So we were planning on moving our family here, and then I actually got accepted to nursing school up in North Carolina, so we delayed our stay, and then in desperation of trying to survive and not lose the house, we listed it like a couple days, and it happened to be the window that, and then when he reached back out, and my husband, and he told me I had changed it. I thought it was 29, and then I changed it, and then he got back in touch with us, and I changed it to the 31, and I get that, and so we've tried to pursue other avenues until I've got 7 more months of nursing school left, till we can even potentially look at financial hardship and me being in school all week and different things. So, and our kids up in North Carolina. So, it was kind of honestly, it was our fault in desperation of just trying not to lose the house.
Understand. And you're currently not residing at 917?
I'm in school up in North Carolina.
What is your North Carolina address for our clerk?
That is 397 Hilltopper Court, Rutherfordton, North Carolina, 28139.
Okay. Okay, board, do you have any?
And it's Unit 3. It's an
Okay.
apartment.
Yeah, I did.
Go ahead.
So you went online and changed the listing time?
Yes.
Okay.
So it's currently, it's still, you can still find it on Airbnb, and I've listed it on a turbo tenant for a longer stay, but the minimum requirement is 31 days.
Okay. Let me clarify what I'm asking. What I'm asking is it had been corrected before, and that at some point you changed the time on it to less than 30 days?
Yes, it was a month, when we had been paying for it, and then the month of I think it was May or June, we were I was no longer able to work, and my classes increased and my clinical, so we were trying to get maybe a little bit of time just to be able to pay the mortgage, to hold us over, and that was wrong on our part, too.
Okay. So if I'm understanding what you're telling me is you went online and changed it in an attempt to just rent it and get some money? Is that the
Yeah.
idea?
Yeah.
Okay. All right, less than the 30 days?
Yeah.
Okay. All right. Thank you. Appreciate that.
So they're admitting the repeat violation?
Yes,
Yeah.
Okay.
for financial hardships.
And so we need to what, read the first motion?
We already have found them in.
Yeah, but that was the first but it wasn't for a repeat violation, first motion.
Oh, no. it
We need to
wasn't.
read that one.
Okay, yes, we do need to read that.
Mr. Chairman, I move to find a respondent.
I'm sorry, when did you start? Oh, yeah, I guess we can go ahead.
No,
and do-
no, if you have another
Because
question.
it's the second motion that
Yeah,
I'm.
I move to find the respondent was in violation of the code as referred to in the affidavit in this case and has committed a repeat violation.
Second.
All in favor? Aye. All opposed? That motion passes. Now.
The floor is yours.
Yeah, now, Mr.
I'm sorry. The only consideration I have about this one is, I understand what the code enforcement officer is asking for in terms of a fine. It would be $500. Part of me just questions what is a fair amount. I understand that it's a financial hardship case. I understand that it's a repeat violation, and so that's all I really have to say. Is that something worth considering, or is it? Is it not?
I think so, yes, I do. I think so.
How was the 500 determined? Is that some calculation or just a,
No, it's actually outlined in the state code what we can start charging repeat violations for, so that's the minimum for like a
That's the
repeat
minimum.
violation is the $500.
That's standard for a repeat.
okay.
Okay.
And how long were they out of compliance?
Ended up being a total of a couple months. I'd have to count up exactly how many days or whatnot. But again, in speaking with them being forthright about it, once I was actually able to get a hold of them and whatnot, giving them the benefit of the doubt is why I'm asking for just the $500 fine for the initial.
Thank
Mr.
you.
Chair, if I may, with the repeat violation, the city, thank you. With the repeat violation, the city can seek a fine from the date that the notice of violation went out up until it was brought into compliance for each and every day. So that for as long as the ad was on the internet, the city could be requesting $500 for each day that it was that ad was on the internet. So we're not asking for that. So I just want to make clear that that is available for repeat violations, but that's not what's being requested right now.
That would be 60-plus days.
Yeah,
At $500 a day,
Or-
30 grand, you're looking at,
on or about 60 days, right, John? On or about,
right around that.
Yes, sir, roughly.
okay, thank you.
Board, do you have any recommendations for this one?
Well, is the correct procedure for this, if there's a hardship, is it, we go ahead and do this motion and then
Well, that is if we.
a reduction could be considered later
Well, that reduction would happen now. We would,
before we do the motion?
I believe so.
I
If we were.
I think the motion's got to be done first. You can't negotiate it before it's been imposed.
Well, we can't
So-
do a reduction.
Board, in your rules, you say that you don't reduce repeat violations.
Oh, okay,
So I just want to let you know.
okay.
Oh,
Okay.
All right.
We can't do that.
There we go.
Okay.
Rebecca Mulder, Code Compliance. I also wanted to let you know that you're asking about our lien reduction process, I think is what the after-the-fact reduction. That process only happens if they don't pay the fine, and then the fine becomes a lien on the property. So if they chose not to pay it within that time given, then it would become a lien on the property, and then they would come before us to request a hardship or a reduction.
And I would add to that normally that happens when they're not in compliance and after the deadline that you impose, and the fine accrues to a certain amount, and now we're coming back to try to reduce it down to something that they can pay. Here, they're in compliance, so we're just talking about what the fine would be, what they would pay, so there's not really a negotiation that's happening. This is just the board deciding what's appropriate.
Okay. All right.
Mr. and Ms. Alencar, do you have any questions?
No, this is all kind of new from the, I
understand.
think, the only thing I was, when he did get a hold of us, obviously, that was on us, but like, the notice where we didn't receive right away is, because we weren't there, and it was not occupied, even though it was under, like, it still wasn't rented out. So we didn't know the notice was there till quite some time after, but, when we did find it, Thiago did get in touch with John, and we figured out we knew, but that was why we didn't deal with it initially when we first got the notice, because we didn't know the notice was on the door.
When you live out of town, that's something you really have to stay up with.
We learned a lot.
So,
We have our neighbor now.
I guess our hands are,
They're tied.
they're tied, are tied in this one, so.
We can't reduce it.
No.
So let's just,
It's fair.
we'll just go ahead with our second motion.
Okay, I move to enter order the fine of $500 per day, well, not per day, $500 for the 60 or about days the repeat violation existed for a total fine of $500, payable within 30 days. If fines and fees remain unpaid after 3 months, a lien will be filed. The city is authorized to foreclose, collect, or settle such lien. If the respondent repeats the violation, the board may order a fine up to $500 for each day the violation continues to exist.
Second.
Which we haven't done that.
No, there won't be.
Second.
All in favor?
Aye.
All opposed?
Good
Motion
luck,
granted.
stay on top of
Thank you.
it. You're welcome.
Thank you. All right, our next up is
Thank you, Board.
3.3 has been withdrawn. 3.4 is continued to January 2026. 3.5, case number 142-25, fine respondent Sugar Factory LLC at 1844 Drew Street in violation of code for fences and walls, exterior surfaces, doors and window openings, roof maintenance, and exterior storage, and issue an order with compliance deadline and fine if compliance is not met. Is there anyone here to represent that case? No? Mr. Casman, you have the floor.
All right, thank you very much, Board. Daniel Casman, Code Enforcement Inspector with the City of Clearwater. This is case number 142-25 for 1844 Drew Street. There are 5 violations here for Code Section 3-1502B for exterior surfaces, Code Section 3-1502 D1, D5 for roof maintenance, Code Section 3-1502 C1, C3, and C4 for door and window maintenance, Code Section 808 1 through 6 for fence maintenance, and Code Section 3-1502 F1 and F2 for exterior storage. This is the date the notice of violation was sent out with the compliance date and the affidavit of posting. This is a strip mall or strip store along Drew Street, 1800 block. I noticed there were a few issues with the exterior. There's some overhangs that are in a little bit of rough shape, some chipped and peeling paint, a big window with a panel over it, missing some of the decorative block on the roof there. In the rear of the property, there's some storage garages with some damaged fence. There's a lot of AC units being stored on the property outdoors. One of the garages in the storage area is damaged. Around the grounds of the property is just various trash debris, somewhat useful objects. The rear of the property could use some paint. Some of the doors are damaged back there with some scrap awning. It looks like laying on the ground. This was the posting of the same day. Went back into the compliance date. There were still the same damages at the property, same issues. The fence area had not been taken care of. There was a pile of debris and just items just hanging out in the back of the building. And the rear of the building still needed some work as well. I went back today, same issues. They did paint one of the storefronts, which does look a little bit better, but there is still some damages to the overhang you can see under there. The decorative brick is still damaged. The rear of the property, the fence some of it was removed, but some of it's still falling over, and they're still missing slats. The rear cleaned up a little bit, but there's still damage to that one door, and they could repaint that area on the lower right there. And this area is still full of a bunch of random items and a few items lying along the fence line. So compliance will be met for the exterior surfaces by removing any chipped or peeling paint and repainting where necessary. Compliance submit for the roof maintenance by repairing any damaged decorative elements or overhangs. Compliance submit for the door and window maintenance by removing any boards from windows and replacing glass, repairing damage to door of the garage or any doors in the property. Compliance submit for the fence maintenance by repairing any damage to the fence or removing the fence. Compliance submit for the exterior storage by removing from the grounds of the property any appliances, furniture, buckets, bins, tires, shopping carts, or other miscellaneous items not meant for outdoor use. For this one, I'm requesting compliance on or before December 19th, 2025, or a fine of $150 per day per violation for each day the violations continue to exist.
Okay. Have you been able to get a hold of the owners of the plaza at all?
I had one gentleman call me about a month ago about these issues. He claimed he was the owner. He said he had some health issues, but he was working with a contractor on site, and I said, go right ahead, give the contractor my information. I'll speak with him. I'll meet him out there. Anything that needs to be taken care of, I'll point it out to him. He said he'd do that, and I haven't heard anything since.
Crickets, huh? Okay. All right. Well, can I have a first motion?
I move to find the respondent in violation of the code as referred to in the affidavit in this case.
Second.
All in favor? Aye. All opposed? Motion approved. Board, do you have any questions for Inspector Castman
No, sir, I
on this one? No?
Pretty straightforward.
Can I get a second motion?
I move to enter an order requiring the respondent to correct the violations on or before December 19th, 2025. If the respondent does not comply by that date, the board may order a fine of $150 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
All in favor?
Second.
Yeah,
Oh, second, I'm
yeah.
sorry.
Second.
All in favor?
Aye.
All opposed? Motion approved. All right.
Thank you very much.
Our next case is 3.6 has been continued to December, 3.7 has been withdrawn, 3.8 has been withdrawn, 3.9 is continued to January. And our next case is 3.10 on our agenda, case number 147-25. Fine respondents Clemente Deza-Taran, Petra Tazanga, May, and Santiago Deza-Taran at 2371 Chaucer Street in violation of code for exterior storage, and issue an order with compliance deadline and fine if compliance is not met. Is there anyone here to speak on that case? No? Oh, yes. Please come forward, sir, right around this way. Please state your name and address for the record, please.
My address is 2371 Chaucer Street.
All right.
My name is Clemente Deza, D-Z-H-A.
All right. Mr. Clemente, do you admit or deny the violation?
And the violation is the unready and clean up.
At the time that you were posted, do you admit or deny the violation? Was there a violation or wasn't there a violation?
But now I can show you the picture and clean up.
Now, I'm just asking you, do you admit that there was a violation or do you deny that there was a violation?
I'm sorry, I don't understand exactly.
Not now, originally.
Before you cleaned
My
it up.
preference would be to just proceed and treat it as a denial.
Yeah.
It sounds like he's saying he fixed it if there was, and I don't know that we are, the city doesn't necessarily take a position that he needs to get or deny.
If we can get, sir, at the time that you received the notice, are you admitting that you were in a violation at that time? Or do you deny that? And then after this, you'll have the opportunity to speak more. But we just need to know at this point, do you admit the violation happened or do you deny that the violation happened?
No, not,
Deny?
no,
It didn't happen?
no.
Okay, so we'll treat it denial and then proceed.
I don't understand.
Okay.
I'm not sure, I'm sorry to interrupt, but I'm not sure he understands.
He does.
And that's also,
You know, so, do you understand what admit means? Like, yes, it was in violation, or no, it wasn't?
No understand 100%.
yeah.
So
It's
that's that.
okay. That's all.
Okay.
That's the
Mr.
way-
Brown, it may be appropriate to table it and see if we could maybe get an interpreter, just to make sure everybody understands.
Yeah, I mean,
Yes, speak Spanish?
May I approach?
yes, please. Is that okay?
Doctor,
We just need to take the extra, she's not official, take the extra step that he definitely understands what she's saying.
Slow down.
Hold on. One second.
Just
Ma'am.
because,
1 second.
because she's not like an official translator, we would just need to be very thorough here in making sure that he understands everything that she says in interpreting, and just be a little extra thorough than we would if we had a formal interpreter, is all I ask.
Mr. Chair, I mean, we normally, when we need an interpreter, we line that up through a company and through an official channel. There's an interpreter's oath. There's a little bit more formality to it, and my preference, if an interpreter.
Your mic, sorry.
Sorry, Robert.
Thank you. I'll stop muting it. Normally, there's more formality to the process of having an interpreter involved. We have a third-party company that we work with. I wouldn't want to stray from that normal process, and if that's something that he needs, we would just ask to continue the matter. I think that would probably be the preference and we can take a look at what he has separately. Maybe the issue can be resolved outside of the board once we see what's going on. So I would just ask for a continuance.
And
That sounds very reasonable.
I'd agree with the continuance to just make sure.
So we could tell
Mr.
her.
Clemente, we're going to continue this case until next month, and to get you an interpreter, so you can understand what we're saying and we understand
I can
everything.
bring
that's-
somebody, my daughter, speak
Huh?
English, I can bring my daughter too, my daughter.
No.
He said there's a company that they use as an interpreter, that
Well,
they.
we've had folks bring their family. I think that's a little bit different, but
Okay.
but outside of that, I mean,
Okay.
we generally go through a process.
Okay.
So he can bring his daughter,
Mr. Clemente, you
he
can.
can bring his
And
daughter to
Mr.
interpret.
Absolutely.
Mr. Brown, the clerk's indicated that she would feel more comfortable if the clerk provided the interpreter, just in terms of,
In this instance, if we had somebody on the city side who could interpret it, I would be okay with it, like if we had somebody here. But like you said, we've had family members interpret for respondents before, and that's not been an issue. I'm concerned about, and no offense, by all means, I'm concerned about somebody popping up from the audience saying, I can interpret, and we don't know.
Okay. So, is it okay that we get an interpreter for the continuance of next month?
Yes.
Okay.
Otra mes,
We'll
en
do that.
diciembre, usted regresa para otra cita con una traducadora de ellos.
Perfecto.
So we're going to continue this case until December 17th is our next meeting.
Diciembre 17.
And,
Let me put it down here.
Diciembre
17th.
17.
And we will have an interpreter here,
What time?
1:30, same time.
Okay.
And we'll have an interpreter here that
Yeah,
can,
because there's something confused.
I understand it, and it's not your fault at all. We probably should have someone on standby at all times. So we just, we
Yeah,
never.
because I need to understand 100% what's the violation.
Yeah.
For me, the city
Yeah.
child was that.
Exactly.
Need do something, agree something, but I need to understand 100%.
Yep.
If I can sign any tip paper,
Yeah.
I understand 100%.
Well, next month, we'll have an
Next month, I
interpreter
wish I
down
could.
here, and it'll be 100%.
Buena suerte, señor.
Thank you so much, Mr. Clemente.
Gracias, senor.
Can I have a motion to continue this case until next month?
Yeah, if we can find it.
I make a
Or-
motion to continue case 147-25 until December 19th, 2025.
17th.
17th?
Is our next meeting.
2025.
Yep.
Second.
Can I have a second?
Oh, second.
All in favor?
Aye.
Aye. All opposed? Motion carries for continuance till next month. All righty, our next, it's going to be continued. Our next is 3.11, On our agenda, case number 148-25, find respondents Costco Wholesale Corp. at 2655 Gulf to Bay Boulevard in violation of code for fences and walls, and issue an order with compliance deadline and fine if compliance is not met. Is there anyone here to speak for that? Yes. Will you please come forward? State your name and address to our clerk for the record, please.
John Davidson, 9178 Highland Ridge Way, Tampa, Florida.
And you represent Costco?
Yes, sir.
Okay. Well, I have a question for you. Do you admit or deny the violation?
Admit.
You admit the violation? Okay. If you'll have a seat right there in front row.
Sure.
We'll have you back up. Can I get a first order, please? First motion, I'm sorry.
I move to find the respondent in violation of the code as referred to in the affidavit in this case.
Okay, hold on one second. Is this a repeat violation?
No.
No, okay.
Second?
All in favor?
Aye.
All opposed? All right, motion carries. Inspector Maddox, you have the floor.
Good afternoon, Board. Kevin Maddox, Code Compliance Inspector for Clearwater. This is case 14825, 2655 Gulf to Bay Boulevard, which is otherwise known as Costco. One violation for Code Section 3-808 for fence or wall maintenance. In this case, it's wall. It's a brick wall. Notice was sent out on May 19th, compliance date for June 20th. Certified mail was received back signed on June 5th. Costco's a very large property here, so I'm taking pictures more toward where the violation exists, which is a wall on the outskirts of the parking lot. I'll give you an overhead view here in just a moment. There were initially 3 sections of this wall that were broken. The one in the, let's see if I can, this one here was repaired in the last couple months. This one was initially assigned to the neighbor, which is Seville Apartments of sort, and I'll show you an overhead where they are. And somewhere it got fixed, and there was an agreement between Seville Apartments and Costco because Costco had a tree fall on it and break it. And then Costco paid them to have the wall built back up, as I understand it. So there remained 2 breaks in the wall similar to this. This was one of them. And this was the second, where you can see the bricks. And the trees there are creating a big problem with these walls. In the Costco parking lot here, this is 19. This is Seville Boulevard. The one break in the wall that I talked about next to the gas stations here, I had assigned to this property, and then it got worked out as people were figuring out who owns this part of that wall. As this red brick wall, which is in a curve type of, it's not straight, it's curved throughout. And as you go around the corner to Seville, there are 2 more breaks, which is what I'm addressing today. But you can see this is a very large property, but the wall is along in here is what we're looking at. On the 20th of June, the breaks, you can see here, the brick has been fixed. So that is one of the 3 that was repaired, and then the other 2 were still down. As of today, this is from the inside. I typically don't take pictures from the inside because it's such a crowded population of people shopping there, and you'll get run over. But the break in the wall still exists. This is the other side of the repaired wall. Compliance can be, before I go into compliance can be met, there was many discussions with the attorneys of Costco, maybe 3 of them that I remember having email conversations or phone conversations, and there was, they were letting me know that there was old paperwork that allowed for an easement to the neighbor, that they had to take care of the wall even though this wall is on their parcel. After all of this information presented was sent to our legal. It was given back to me that there wasn't enough evidence to change the ownership of this wall. So I reported back to the last attorney, which was Linda Blue from Costco. I told her there was not enough evidence showing the wall was the responsibility of the neighboring parcel. Costco was be responsible for, as the owner on record for the Pinellas County property appraiser. And then Costco would be responsible for communicating with the neighboring parcel owner, reference their agreement. And that would not be on us. We would be just holding it to what's on property appraiser. So with that, the last information I had was that Linda Blue had someone coming out to take a look at the wall on November 4th, and I haven't had communication after that. Compliance can be met by repairing and maintaining the wall in a structurally sound and aesthetically attractive manner as outlined in Section 3-808 of the Clearwater Municipal. For this case, 148-25, requesting compliance on or before December 19th, 2025, or a fine of $150 per day per violation for each day the violation continues to exist.
Board, do we have any questions for Inspector Maddox? No?
No, sir.
You can come back for Mr. Inspector Maddox. If you'll just step over to the side there. So have you guys got contractors and stuff ready to get this wall?
Yeah, the estimated repair is December 1st. There was some issues with the insurance that the person who was going to fix the wall carried, and we needed to make sure that was rectified first.
Okay.
So we have a date of December 1st.
December 1st,
Yes.
it'll be done and everything? Okay. Board, do you have any questions for?
No, if the compliance date is the 19th, that would seem enough time.
Yeah, that seems plenty of time, you know. If there happens to, we're just gonna go ahead and stay with this order, but if there happens to be anything that would delay the first, make sure you get in contact with Inspector Maddox so you can keep him up to date on what's going on, if there is a delay from the December 1st timeline.
Yeah, at least you'll have till the 19th
Yeah.
if something happens.
Yeah.
And if, you know, if something happens that's gonna extend out beyond that, you know, make sure you get in touch with, or whoever, the representative, get in touch with Mr. Maddox. All right, Board, do you have any more questions? No? Can I get a second?
I move to enter an order requiring the respondent to correct the violations only before December 19th. If the respondent does not comply by that date, the board may order a fine of $150 per day, but per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second. All in favor?
Aye.
All opposed? Motion carries. Thank you, sir.
Thank you,
Appreciate
Mr.
it.
Davidson.
Thank you.
All right, next case on the docket is 3.12 on our agenda, case number 149-25, fine respondent Sarah Butler at 204 Brigadoon Drive in violation of code for exterior services, and issue an order with the compliance deadline and fine if compliance is not met. Is there anyone here to? You guys? Hi. If you'll come up and state your name for the. Come up and state your name and address to our clerk for the record.
Sarah Butler, 204 Brigadoon Drive, here in Clearwater.
Okay, Ms. Butler, do you admit or deny the violation?
There's no violation.
So you deny the violation?
She's unaware of what violation exists.
Okay, well, we'll
take that as
the
a
city will show us what the violation is. I just needed her to answer whether she admitted or denied the violation.
I can't admit or deny if I can't see.
Okay. I'm just going to take that as a denial then, And if you'll have a seat right there, we will have you back up in just a second. Can I get a first motion, please?
I think we don't, since they've denied, the city needs to present its case.
Oh, okay.
then.
I'm sorry. Go ahead, Mr. Daniels, you have the floor.
Thank you. Good afternoon, board.
Good afternoon.
Good afternoon, board. Inspector Daniels, case number, code compliance inspector, case number 149-25 for 204 Brigadoon Drive. One violation, code section 3-1502.b for exterior surfaces. The notice of violation was sent out on 4/11. Compliance date was 5/21. Certified mail, signed back in the office, April 29th. There go the posting for the hearing today. Right there, we got the rotten wood in that area there. That needs to be replaced. Piece of fascia board missing, a hole in the fascia. The side needs to be pressure washed and possibly painted, I'm not sure. And that was on 4/10. This was after the compliance date. Nothing's been done. And then these are the pictures from today. Nothing's been done.
Can you go back, slow that down a little bit? I went by too fast. Can't see them. Yeah, start there.
So yeah, that's from today. That's from this
Yeah,
morning.
I know, but it went by, you did it so fast, we couldn't see it.
Okay, same area.
Okay,
Fascia still has the hole in it. Still
that's the
rotten-
one, okay.
Yeah, rotten wood still.
Thank you, Jerry.
And the side still not pressure washed or attended to. Compliance can be met for exterior surface by replacing any defective structure and decorative elements of any building walls and ensure all exterior surfaces are free of mildew, rust, loose materials, and faded or peeling paint. So it's one violation, requesting compliance on or before January 1st, 2026, or fine of $150 per day per violation if compliance is not met.
All right. Board, do we have any questions for Inspector
Yes.
Daniels?
I do. Have the owners been in contact with you on this?
No, sir.
Okay. And your phone number, and contact information is on the violation that was
Yes.
not only signed for, but that was posted?
Yes, sir.
This is the first time you're seeing the owners?
Yes, sir.
Okay.
Thank you.
Any
Thank
other-
you, Inspector.
Board, do you have any other questions for Inspector Daniels? No. Ms. Butler? You. Did you get a good look at the pictures
Yeah.
of the rotting wood and the mold and mildew all down the side? That's no
Well,
good.
what we don't understand, though, is there's a homeowners association. We were in, if she was in violation of such, they would have notified her. Now, there was a notice that was sent out for the pressure washing, and I'm here because I paid Andrew Cook, the contractor, who, I have a picture here, who pressure washed the entire building side.
When did the pressure washing happen?
That happened December 2nd, 2023. And there he is in the picture. He's pressure washing the entire house.
That was almost 2 years ago.
Yeah.
Well,
Mold grows in 2 weeks in Florida.
If I could just interrupt, could I get your name, sir?
yeah, my name is George Jokas. I'm at
What was
the-
last name?
T as in Tom, Z as in zebra, O-K-A-S.
Thank you.
She's a little bit of a hardship, so I help her out as far as the pressure washing. I remember paying him $180. I'm pretty sure I have it on
No, that's- but that was
Zello.
also 2
Yeah.
years ago, you know?
Yeah, well, I can certainly have them come back and do it again. It's not a
That's
problem. It's just pretty much surface dirt. I mean, usually mildew doesn't come back that fast. It's mostly probably just from the hurricane. And it's mostly just dirt, mostly. It's not going to be mildew because he did use chemicals, and we did buy them at Home Depot. And I'm sure the mildew is gone, but I'm sure it's just some debris from the hurricane that could just have to be pressure washed off. But that's, I mean, she did it when the violation occurred with the homeowners association.
Well,
So-
the homeowners, if I'm correct, and you can correct me if I'm wrong, even though they are in a homeowners association, you still have to obey the Clearwater code enforcement, whether you're in a homeowners association or not. Now, whether the homeowners association chooses to violate her because of that, that's up to them. But you still have to go within the city's codes, you know, and rotting wood, and fascia missing, and the dirt on the side, that's violation of the city's code. It may not be of the homeowners association, but I'm pretty sure that them homeowners associations are really strict on everything, you know?
Well, they are, and,
so-
it's, I think it's a little nitpicking here. I don't know what the dynamics between that gentleman and Sarah are, but I know within the area, there's a lot worse, you know?
Then that's her
So-
job as a citizen of Clearwater to call our inspectors and get them out there to take care of that, you know? That's the beauty of, you know, being able to call the inspector when you see something that's not right.
Yeah.
Ms. Butler, are you going to be able to take care of all this before, it's 2.5 months from now, before January the
I
1st?
make reasonable efforts. That is what I can promise you.
She's not working right now.
That is why I'm saying,
She's in between jobs. She had a seasonal at Macy's, and she's not working. She has a 11-year-old daughter, which we got to go pick up by 2:40 at Athenian Academy, and she's just making ends meet right now. So maybe an extension, if you guys would be kind enough to consider that, might give her a little bit more time. She is interviewing currently, so.
I have a question before we get much further.
I got one too. Go ahead.
Is this a condominium? or-
It's a townhome.
Townhome.
I have a comment that might answer your question, Bob.
Well, I was just going to make the observation that this may be the same thing you're talking about, that typically with the homeowners association, they're responsible for the exteriors of this thing.
Not at Brigadoon.
Not Brigadoon.
Not at Brigadoon. If I'm not
Okay.
mistaken, Brigadoon does not cover exteriors of the building, and that's the
Okay.
owner's responsibility.
Well, and that would make
And that-
sense about why we have individual cases. on
And
this
that is
property.
why, that's correct, and that is
Okay.
why the maintenance fee is so low there. Each owner is responsible for the exterior of their building, including the roof.
Okay.
I'd like to make a comment too, Mr. Chairman. George?
Yeah.
It's not nitpicking rotten wood.
No,
The
I
inspector's
understand.
not nitpicking.
I was
He's
about
not
the
nitpicking
dirt.
you.
It was about the dirt, I was saying, on the side of the
But
building.
either way,
Yeah.
violations aren't nitpicking.
The thing that I would point out too is that the pressure washing was done in 2023, and the violation occurred much after that, and is much more than the pressure washing. And per the inspector's comments, correction can be done by either pressure washing and/or painting. So if the pressure washing doesn't correct it, then it's on to the next step, that if whatever it takes to create it, plus the rotten wood and, you know, other things that are pointed out have nothing to do with the pressure washing. Those are separate issues.
Yep, you're right.
What I would, I could see if it's dirt is one thing. If it's mildew, make every attempt to have it pressure washed and remove a hazard such as mildew, but I don't see how her being in an area where she's not exposed, it's not a connecting wall on her side on that area, you're gonna get the debris from people who are mowing her lawn up and down the ramp. So just by nature, it's gonna cause wind to go up and put blades of grass up there and dirt from the mowing from where they utilize the ramp to get to the back to mow. There's constant people and traffic
I
going
understand.
through there. So, I mean, I don't see, I could see mildew, yeah, hold her accountable for that, but dirt, that's a little, that's tough
I
when you're in an exposed wall and there's people mowing with tractors. That's a little harsh, I think.
Understood. At the end of the day, per the code, it's the homeowner's responsibility.
You grab the garden hose and you do this on the side of the
Yeah, we
building.
can do
after,
that. That's all
you
I'm
know,
saying,
That
it's
gets all the
surface.
dirt off, and then
Yeah.
the picture wouldn't have been in front of us. It would
Yeah.
have just been rotten wood.
And one more suggestion, she can always have that
You know.
wall painted with mildew-resistant.
That costs a lot of money. It's very high.
Yeah, but you save in the long run
Yeah,
of
well-
having a
At the
pressure washer.
moment, sir, if I may say so, with grandest respect there is, at the moment, I'm interviewing with every bone in my body trying to get a job.
They're gonna want.
Painting, fine, I understand, and in compliance with the association. But to get something where the price is this high, and over there, it's cutting an arm.
Well, either way, it has to come into compliance.
Yeah.
You know.
That's not a problem.
What-
I
but
understand that.
we're-
Well, that is
I'm
a
just-
problem.
I'm
Painting's
just
like 1,800.
Trying to
and
figure out,
Extension, yeah.
yeah, you want to extend, board, you want to extend this out until February
How
the
much,
first?
the question is, how much time do you need to get into compliance to repair the rotten wood and the violations?
Are you asking?
I don't know. I mean, these
Well,
look
they're-
like pretty expensive things. I mean, replacing fascia all the way up there, that's gonna cost an arm and a leg, and painting the side, that's a lot.
Plus the foundation is rotting out too, the boards on the foundation.
Is
Yeah,
that a
just-
violation too?
Well, it could be just trim, but you need to check that too.
Yeah.
The what now?
It could be just trim, as Bob says. You need to check any rotting wood.
Oh, just like the surface maybe, like the whole thing doesn't
What
have
his
to be
picture
replaced?
showed. What the inspector picture showed.
Yeah,
Needs to be
rotted
taken
wood.
care of.
Yeah, that's
Yeah.
gotta be replaced.
Yeah.
You know, at the end of the day, I would suggest communicating with the code compliance officer to find out exactly what needs to be done to be brought into compliance, get that done, and you'll be fine.
The board, do we have a problem extending this out till February the 1st
No.
instead of January the 1st?
Well, the inspector's already told them what to do to come into compliance.
Yeah, I know, but she's trying to.
It's a
she's trying to gain
financial matter.
employment. She's trying to navigate a lot of things right now.
I
so-
know, I'm just saying, before we get to that other part
Oh.
of an extension, he already has told him what to do to come into compliance. The extension is something separate.
The extension would possibly give her time to get a job.
Yeah,
and
I
have
know
money
that.
Put away, that's why
And
I asked, that's
contractors
why I
and-
said for the extension. You know,
I'll
but
just-
it's a, whatever, you know, the board decides. But I would be in favor of putting it out till February the 1st. So you guys can mull it over.
Yeah, Mr. Chair,
Yes.
we don't take a position on how people make repairs. The exterior surface code just says if it's defective, then it has to be repaired. Whether or not that board on the bottom is structural or it's just decorative, or we don't do that kind of engineering analysis. It's just on its, you can see from the outside that it's rotten, and that's what makes it a code violation. With the side, the code does specify mildew and rust. It doesn't say dirt, so the code is actually specific to the mildew and the rust aspect. Whether that means that they have to just pressure wash it, or they have to paint it, or what the extent of the repair is, we don't really dictate that. It's just if there is mildew and rust, then it's a code violation. How that's remedied is kind of on them. And then I guess I would also say that with Brigadoon, that's a complicated situation that I've had quite a bit of involvement with over the last couple of years, and so have several other inspectors with the city. And we've been making every effort that we can to work with the unit owners in the association out there. So we do recognize that, it's complicated and there's a lot of moving parts, and so we are fine if the board wants to give a little bit of grace on the deadline, but the deadline that was recommended to you is our standard recommendation for exterior surface violations.
So February, Mr. Chairman?
I mean, if that's all right with everyone, till February the 1st, then yeah, I would do that, so.
Yeah, we're fine.
Yeah, okay, make a second and.
Does that mean it has to be corrected by that date, or contractors in place?
No, it needs to be corrected by that date, come into compliance, that's 2.5 months.
Okay.
That's,
So pressure wash and a couple of the boards that we've seen on the picture, can we
Get
have
with the
a
inspector.
copy?
Get with your inspector. He'll tell you
you
what
could
to
find
do.
that when you pop in boards off there, they're decorative trim, and all you gotta do is cut a new board and put it up
Right,
there and paint
right.
it, and you're done, you know, $12. You know, board and some paint.
Yeah.
That's right, yeah.
And you may find you pull that off of there, we got a bigger problem than this, you know?
At
Who
the end
knows?
Well, who's gonna pull it?
At the end of the day.
I'm not.
You are.
But you are.
Inspector on
If
the
you're doing,
repairs.
if you're doing work for her.
It's up to you.
Liaise with your inspector on the repairs.
How about
That-
pictures?
That's liaise with your inspector on the repairs, because he's the one that's got to deem
Oh,
that comes
okay.
into compliance. Yeah, okay?
Yep.
All right, okay.
Let me get a second.
I move to enter an order
How do we
requiring.
obtain the pictures so I can show a contractor what needs to be done?
Talk to your inspector
Yeah,
for
ask
compliance.
Inspector Daniels, and he may be able to text them over
Yeah.
to you, or there's
Yeah.
a way that you can get this information that's was
And
put
then,
up on that
on a
screen.
side note, I've been trying to correct something that's been occurring for years. At my residence, my next-door neighbor has been out of compliance for years. Who do I speak to is what I'm trying to say, because I
to the
spoke to a
inspector.
Vicky, and I haven't gotten anywhere for over 6 months.
One of our inspectors right there.
George,
Okay.
talk to the
All
inspector,
right.
yeah.
Let me get a second, please.
I move to enter an order requiring the respondent to correct the
I'm
violations
sorry,
on or
real quick,
before.
we need a first motion, we don't have a
Oh,
first.
we didn't get.
We didn't get one?
I'm sorry.
I move to find the respondent in violation of the code as referred to in the affidavit in this case.
Have a second?
Second.
All in favor?
Aye.
All opposed? First motion passes. Now can I get a second?
I move to enter an order requiring the respondent to correct the violations on or before February 1st. If the respondent does not comply by that date, the board may order a fine of, was that $150?
Yep,
150.
$150 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor?
Aye.
All opposed? Second motion carries. All right. Next one is 3.13 on our agenda, case number 150-25, fine respondents Edmund and Rosemary Fretchman at 1103 Brigadoon Drive in violation for code exterior surfaces and exterior storage, and issue an order with compliance deadline if fine if compliance is not met. Is there anyone here to represent that? Will you please come forward?
Here we go with Brigadoon again.
There was another Brigadoon that was
Yeah.
withdrawn.
We're down to 4.
Oh, really? Wow, Brigadoon, man. They are old. Yeah.
Four.
Yeah.
Good afternoon. Could you state your name and address to our clerk for the record, please?
Edmund Fretman, 1103 Brigadoon Drive, Clearwater, Florida.
Mr. Fretman, do you admit or deny the violation?
Admit.
You admit it? All right, can I have a first motion?
I move to find the respondent in violation of the code as referred to in the affidavit in this case.
Second.
All in favor?
Aye.
All opposed? First motion carries. If you'll have a seat right there, we'll hear from the city, and then we'll bring you back up, okay? Thank you.
Good afternoon, board. Jared, the inspector, code inspector for the city of Clearwater.
Jared, code inspector.
We know who you are.
The backlash of this is that we went through because of a resident complaint in Brigadoon, and we inspected every single unit in Brigadoon.
They were collateral damage.
And the ones that's coming before you now are the ones that have not made any contact.
Okay. Okay, thank you.
Okay, so this is case number 150-25, 1103 Brigadoon Drive. It's 2 violations there, but as of this morning, it's only 1 for exterior surface. The exterior storage and construction material storage, they fixed that issue.
Okay.
The notice was sent out on 4/11. The compliance date was 5/21. Certified mail was received, the receipt was received signed on 5/6/25. There's the posting for the hearing. That's the construction debris that was stored outdoors, but they have moved that. That was on 4/10. This was on, after the compliance date. That was after the compliance date, and then this was this morning. This is the area of concern, rotten wood, maybe some mildew, need to pressure wash, maybe paint. And then up here, this needs to be painted, and this little area pressure washed and fixed. Compliance can be met for the exterior surface by replacing any defective structure and decorative elements of any building walls and ensure all exterior surfaces are free of mildew, rust, loose materials, and faded or peeling paint. And the outdoor storage is already removed. So, requesting compliance on or before January 1st, 2026, or a fine of $150 per day per violation if compliance is not met.
Board, do you have any questions for Inspector Daniels?
No, sir, I know.
Mr. Fritzman?
I do. You mentioned that in this case, you haven't had any communication from the owners?
Yes.
You have or have not?
I have not.
Okay, thank
I
you.
have not.
Appreciate it.
Mr. Fritzman, you've seen the pictures and stuff. Do you think that you're going to be able to get everything in compliance by January the 1st?
Yeah, that's the back of the unit, it's a storage unit. We never go down there. So, yeah, I'll get that wood replaced. But as far as the mildew, I got to say one thing. We live where there's a part of a creek or a river that's back behind us.
No.
Okay, that place is full of mold and mildew. Okay, the park department is not cleaning that up. You know, for the back of our unit to have mold and mildew, I think probably part of that is the cause of that water back there. I mean, birds can't even land in that water back there. It is. And I got breathing problems. I'm on a puffer all the time. And with all that mildew and moss growing in the back, it's killing me.
Yep.
You know, so a couple units going to get painted, and I'll just pay, to have ours pressure washed at that time, and we'll get the mildew taken care of. But God,
do we need more time? Do we need more time?
Well, the other two units they're going to get painted, in a short period of time.
I'm not sure who you would contact, but I'm sure you could go on the city's website or find some resources on who is in charge of that creek, and then, get with them, and to maybe you can get a few of your neighbors to contact them, and they'll come out and they'll dredge it, clean it up, cut stuff down to try to keep the mold and mildew down,
Well, there's 3 lakes there, and all of them is full of
Well, that would be
growth.
something that you and your neighbors would have to get together and figure out
Sure.
who's in charge of taking care of those lakes, and then get with them and everything. But we're gonna go ahead and make a second motion and have it on the 1st of January. Is
Sure.
it be okay?
Yeah.
All righty, sir, I appreciate it, thank you.
Very good.
Can I get a second motion, please?
Thank you.
I move to enter an order requiring the respondent to correct the violations on or before January 1st, 2026. If the respondent does not comply by that date, the board may order a fine of $150 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor?
Aye.
All opposed? Motion carries. All right, next case on our agenda is 3.14, case 151-25. Fine respondents Matthew and Lisa DeRoma at 1104 Brigadoon Drive in violation for exterior surfaces and issue an order with compliance deadline and fine if compliance is not met. Is there anyone here to represent that case? Will you please come forward, sir? Ma'am. Hi, will you state your name and address to our clerk for the record, please?
Yes, Matthew and Lisa DeRoma, 1104 Brigadoon Drive, Clearwater, Florida.
Mr. and Mrs. DeRoma, do you admit or deny the violation?
I admit it.
You admit it? All right, we'll have you have a seat right there, and we'll let the city come up. Can I get a first motion, please?
I move to find the respondent in violation of the code as referred to in the affidavit in this case.
Second.
All in favor? Aye. All opposed? First motion carries.
Good afternoon, Board. Jared, Code Inspector, City of Clearwater. Case number 151-25, 1104 Brigadoon Drive. One violation here for exterior surfaces. The notice of violation was sent out on 4/11. Compliance date was 5/21. Certified mail receipt came back signed 4/29/25. And this is the unit here. So we got a little, like I say, the backside is mold and mildew, whichever it is. And that was on the date, the initial date that I went out there. This was after the compliance date. Still the same. Still the same. And then this was from this morning.
And that's right next door to the...
Right next door, yes. That's
to
the
the-
next door neighbor. Yeah. Yeah.
Everybody got kind of...
Can I ask you a question about that picture?
Yes.
These sides, these walls that we're seeing, are those facing north?
East.
You know, east?
I don't know, I bet they're east.
They facing north,
Hold
yeah.
on, I'm sorry, sorry. It's only because it's not heard on the record, that, not because, yeah.
Yeah, it's facing north. It's on the north side of the complex.
They're all sharing the mold.
Yes.
Facing north, if the sun doesn't get to them.
Yeah.
Compliance can be met for exterior surface by replacing any defective structures and decorative elements of any building walls and ensure all exterior surfaces are free of mildew, rust, loose materials, and faded or peeling paint. We are requesting a compliance on or before, I'm sorry, that's an error, by January 1st, January 1st, 2026, or a fine of $150 per day per violation if compliance is not met.
Board, do you have any questions for Inspector Daniels?
Yes, have the owners of this property been in contact with you?
I spoke with them once, and then I got no more contact with them. They did call me once for an extension, and then I heard nothing else from them.
Okay. Thank you.
All right. Will you come back up, Mr. and Mrs.
That's a good question.
DeRoma? You think you're gonna be able to get this all taken care of by January the 1st?
Well, what I was going to do is I was going to ask for an extension to the February 1st deadline, just like one of the other homeowners did. But I did bring with me proof. We have paid the hundreds of dollars for paint, and I did pay $1,200 deposit for a paint guy that has not shown up.
That was nice.
Oh, wow.
Oh, yeah, but I have all the paperwork here if you guys wanted to see it. So remediation is in progress. So it is a project in progress, and we've already spent close to $2,000 of our own money without remediation yet.
Contract signed and everything.
Okay.
Yeah, we 15 gallons of paint
And you
sitting on the
haven't-
back porch.
haven't
waiting to
heard
be
He
done.
gave us his lab, no, he keeps giving excuses. He even brought all his ladders and then still.
Well, you got
goes
some
to us-
collateral
And
then.
then still goes to us.
Some ladders.
We were hoping to have it done by the
It-
beginning
I-
of the
I
month.
want- yeah, and I
We
wanted
wanna
it-
see the paint, the pictures, like we have the paint sitting out there ready to go.
But there again, with the north-facing wall, it doesn't get any sunlight, and it is facing the creek that was mentioned before by our neighbors. And as somebody who got TB in Bosnia when I was in the Army, I struggle with breathing issues as well. And the creek is a very big, and it's the watershed for Alligator Creek that's in question.
One suggestion, again, I understand your mold problem. My apartment faces north too.
Yep.
But, in your paint, consider using mold-resistant
We
paint.
did, and that's why it was so expensive.
Yeah.
No, we spent we went over to Pittsburgh Paint and got the good stuff.
Good for you, man.
Yeah, we went right over to Court Street, and they gave us what we needed for the price that we were willing to pay. So, but I have all the paperwork if anybody would like to see it, but I was gonna follow up with him. We'll get it done. But there again, the new roof just went on back in May. The hurricane windows and doors went in last year. Paint was last on the list because it was considered cosmetic as opposed to structural.
So you need an extension?
Yes,
Problem?
please. We were looking for the February 1st deadline for next year as well.
I don't see a problem with that.
Me either,
Does
Mr.
anybody
Chairman.
else? No? Okay, we want to do a second for
Why
February?
don't somebody else take one?
Oh, I'll do it.
Stranger. No, give one of these guys a turn.
No, I'm asking.
Make them
Go
work.
ahead, Mr. Strickland.
I move to enter an order requiring respondent to correct violations on or before February 1st, 2026. If the respondent does not comply by that date, the board may order a fine of $150 per day per violation. For each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Have a second?
Second.
All in favor?
Aye.
All opposed? Motion carries.
Just one more thing too, with the picture that was in question about his chimney, my roofing company fixed that, and that's why there was this disparagement in paint. I'm gonna be painting his chimney so that is in compliance. It's all part, we've been neighbors for almost 10 years. We're both veterans. We try to look out for each other, so we'll get it done.
It's the way communities need to be.
Well, that's the way community's supposed to work, so thank you.
Great.
All right.
Thanks for coming
Yeah,
to see us.
thanks, guys.
Good luck.
Have a great day.
Yeah, thank you.
We'll be in touch.
All right. next
Thank
up-
you, sir.
Next up on our agenda is 3.15, case number 152-25, Find Respondents Trust, 1201 BC Sierra Rafael Trey at 1201 Brigadoon Drive in violation of code for exterior surfaces and exterior storage, and issue an order with compliance deadline fine if compliance is not met. Is there anyone here to,
Here he is.
come on up, sir?
You're good on those names, man.
Yeah,
Give your
And the
name and
answer is
address. to the-
Serious.
But there is a problem. I did not know about the violation because the city, for some reason or other, has the wrong address. I got this on Tuesday.
Okay.
What is your name, sir?
Yeah, what's your?
I mean, I'm sorry, Thursday, last Thursday, Rafael Sierra. Sorry.
Your address, sir?
Yeah, the correct address should be 2813 Gulf to Bay Boulevard, number 460.
Do you,
Sir-
do
yeah.
you admit or deny the violation, sir?
Yeah, he's right.
Okay, all right, I'll have you sit right there and we'll let him put his game. Can I have a first motion?
I move to find the respondent in violation of the code as referred to in the affidavit in this case.
Second? All in favor?
Aye.
All opposed? All right, first motion carries.
Good afternoon, Board. Inspector Daniels, Code Compliance Inspector, case number 152-25, 1201 Brigadoon Drive. 2 violations there, Code Section 3-1502.B for exterior surfaces, and Code Section 3-1502.G.1 and G3. Exterior storage and construction material storage. The notice of violation was sent out on 4/11. Compliance date was 5/21. Certified mail signed, returned on April 29th, 25. And here's on the day that we did the inspection, 4/10. Not terrible. There go the outdoor storage. Some cosmetic things to the wood and some mildew and things on the outside. Little cosmetic around the doors, the sliding glass door. And that was from today, still getting worse. Chimney needs a little work. it's still there. Compliance can be met for exterior surfaces by replacing any defective structure and decorative elements of any building walls and ensure all exterior surfaces are free of mildew, rust, loose materials, and faded or peeling paint. Compliance can be met for the exterior storage by removing all items that are not made for outdoor use and remove all construction materials from property. Requesting compliance on or before January 1st, 2026, or a fine of $150 per day per violation if compliance is not met.
Board, do you have any questions for Inspector Daniels?
No, sir.
Same question as before. Have the owners been in contact with you?
No, sir.
All right, thank you.
Mr. Cyril, if you'll come back up. Do you have enough time, January 1st, to get all this taken care of, yeah?
Actually, the construction material will be gone before I leave, but I'm going out of town and I won't be back until late December, so if you don't mind, I go into the February 1st will be great.
February 1st.
And I'll make sure everything else gets done.
All right, okay. Is that board, are you?
I have a question. Is there a reason you didn't contact the inspector?
Yeah, I didn't get this until last Thursday. And the other stuff I never got because they didn't have my mailbox number on it. So it just got put somewhere. And then this was sent out on October 26th, I think it was. And I didn't get it until last Thursday. And that's because they actually tracked me down at the old place, not because that's the only reason why I knew about this today. So that's why when I saw him today, because I would have called him immediately as soon as he would have told me, because if I know I have a problem, I would have just fixed it.
Thank you for your explanation.
For clarification, Board, and for your knowledge on the property appraisers,
About to say,
They're missing the box and the address is wrong. It's
so
obvious.
that's what we have to go by, is what's on property appraiser?
I don't know, I corrected it, but
Yeah,
I'll
so
try again.
that's why, that's.
no, I'm not blaming anybody.
Okay.
Just saying the reason why I didn't know. That's
Okay.
not blaming anybody except I didn't know because
I have a question. How did the return receipt get returned on April 29th?
well, this is a mail service box. And if regular mail, they stop forwarding. They changed numbers on last year. And so the mail, the carrier, I guess the same carrier's been going around and he knows some people, and when it registered, they actually try to track it down. But regular mail, they don't.
So did you sign the?
No, it's the service that I pay for. So, because I travel a lot.
Okay, so someone knew of the violations on April 29th, where
No,
before?
because they would have found me and I would have received it. So that one I never saw. This, like I said, I got it last Thursday.
Right, I understand that.
Rebecca Mulder, Code Compliance. Just to clarify, I think what the board, on what you're asking. So the initial notice of violation in which Inspector Daniels sent out,
Yes.
certified, that was signed for. It sounds like you may have a service that does that for you. So that was signed and received back. I think what he has in his hand is the second notice that received
Right.
from Nicole from the clerk's
Right.
office related to this hearing that may have gotten delayed in making it to him, but the initial notice of violation was signed for.
By whom, do we know?
Whoever signed for it, but it doesn't really matter.
Do you-
Now that I know,
Yeah.
I'll
Do you
deal
know?
with it.
Does
Yeah,
it-
so it
So-
was
so-
signed for, and then,
No,
so
I-
therefore, we didn't post the property with the information on it because I had a signed green card back.
Right.
I guess the service is allowed to sign your name for
Correct.
mail
Yeah.
like
I didn't-
that, without contacting you and say, hey, you've got something here that we had to sign for. Okay, so,
It says over here.
yeah. So board, do you have a problem with February 1st?
No, make it easy for the inspector.
Yeah?
Ready?
All right, someone want to give me a second motion?
I move to enter an order requiring the respondent to correct the violations on or before February 1st, 2026. If the respondent does not comply by that date, the board may order a fine of $150 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor?
Aye.
All opposed? Second motion carries. All right, next on our agenda is the next one to hear is 3.22, case number 159-25. Find respondents Mac Ventures LLC at 1600 North Myrtle Avenue in violation of code for landscape and issue an order with the compliance deadline and fine if compliance is not met. Board, we have a written statement by the property owner for 1600 North Myrtle Avenue that was in your agenda, or in your packets this morning, or today. If you want to read over that, I'll let the city go ahead and present their case. There's no one here to represent this case, so we will take that as an admission. And can I have a first motion?
I move to find the respondent in violation of the code as referred to in the affidavit in this case.
All in favor?
Aye.
All opposed? First motion carries. Inspector, you have
Good
the floor.
afternoon. I'm Robert Robichaud, Land Development Arborist. The address in question is 1600 North Myrtle Avenue. They have one violation. Their landscaping is deficient. Their initial notice was sent in January with the mail returned the 23rd. Compliance can be met by replacing the missing shrubs and ground covers throughout the property as they are shown on the landscape plan, as well as all the trees. This is the initial inspection. There's a obvious lack of maintenance, severe overgrowth. The shrubs that are supposed to be bordering the property are missing. In the landscape islands, shrubs missing and more overgrowth. Declining trees and missing shrubs, as well as more overgrowth due to a lack of maintenance. Missing trees, declining trees, and missing ground covers. And there is more of the absent border hedge as well as overgrowth. This is the landscaping today. They have started working on it as of last week. Clearing out the overgrowth. I did get contacted by someone who was, when I met them on site, they have one person contracted to do the removals and another person contracted to do the replacement. I was not contacted until yesterday afternoon by the person doing the replacements. Earlier this week, they did clear the lot of a lot of the overgrowth, as well as removing the declining trees. But nothing has been replanted yet. So there's been improvement, but still no progress in getting the landscaping back into compliance. So we're requesting a $150 fine each day after December 1st because of the length that this is since the original notice.
Okay. Board, do you have any questions?
Yes. What is your, what's your viewpoint on extending this per the, Mr. Benning's letter? We're asking for an additional 30 days till the 1st of January.
Since I was reached out to yesterday by the person doing the replanting, I don't have an issue with it.
Okay, thank you. Appreciate that.
Board, do you have any other questions?
No.
And we don't have does anyone have an issue with bringing that to January, the 1st?
Working on it.
Is that what? Yeah, in the letter, he says during December. Is everybody okay with? 1/1/26?
Yeah,
All right.
we're good.
Okay. Well, let me get a second motion then with that date in place of December 1st.
Okay, I move to enter an order requiring the respondent to correct the violations on or before January 1st, 26. If the respondent does not comply by that date, the board may order a fine of $150 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid, 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor?
Aye.
All opposed? Motion carries. All right, now to old business items. Accept the affidavits of compliance for cases 4.1.1 through case 4.1.11. Can I get a motion?
I move to accept the affidavits of compliance as listed.
Second.
All in favor?
Aye.
All opposed? All right, that brings us to 4.2 on our agenda is continued from October 22nd, 2025. Oh, that is continued till next month, I'm sorry. And 4.3 has been withdrawn. Our next is to consider the 5.1 on our agenda, consider the request by petitioner Ryan Gallagher for a partial release of lien as recorded in OR Book 22-164, page 2617, and OR Book 22-853, page 646, regarding 1234 Eldridge Street. That is,
Mr. Chair?
Yes, sir.
If I could give a little explanation of this one, I don't think that this board has actually seen a request like this before, but when a code enforcement order is recorded in the public records, it becomes a lien against all personal and real property owned by the violator, and it essentially impacts all property that they own within the county. So when you have a company that owns multiple properties, maybe some properties in St. Pete or Largo, in this case Largo, that lien would, what we call cross encumber those other properties. So the request before you today is essentially to partially release the application of the lien to a property that's outside of the city. I spoke with Mr. Gallagher over the phone. He's going to tell you his situation, and it'll be up to the board to decide how to handle it. A couple of things that I just want to give to you for context. This property, 1234 Eldridge Street, it is not in compliance at this time. The fines continue to run. If the board approves the request today, we would still have a lien against that property in Clearwater. We would still have the ability to foreclose on that lien, and in fact, we are, this is one of the properties that is going to be moving into that process if it's not corrected soon. I actually have an agenda item prepared for this right now. Since Mr. Gallagher got involved, I did get a call from a gentleman earlier this week who claimed to be the owner of 1234 Eldridge. And so Mr. Gallagher apparently was able to get a hold of that person and have them contact me, even though our office has been sending demand letters essentially notifying them that we're going to foreclose on the property soon. So that's a little bit of progress. I'm supposed to meet with that person virtually soon in the next few days to discuss what's going to happen in terms of foreclosure and compliance with Eldridge Street. With that, we don't have an objection to the partial release because we still have the lien on the Clearwater property that we can foreclose on. But for the board to keep in mind that usually this cross encumbrance is a tool that increases the leverage that we have over property owners to come into compliance. So it is a useful tool. It is a piece of leverage that the board would, essentially be waiving and the city would be giving up. But given the circumstances, everything that I've explained, we're not overly concerned about it. And ideally, this cross encumbrance would have helped us at the time that Mr. Gallagher purchased the property, which that didn't happen, and he'll explain to you. But that's ideally when the cross encumbrance helps, is when they're trying to sell the property and then they can't sell the Largo or the St. Pete property. They can't sell it because of this cross encumbering lien. Unfortunately, it didn't work like that, and I'll turn it over to him to explain the details of that.
So this is taking all the other properties out of the picture.
This is specific
and-
to the Largo property, so this partial release is essentially saying Veracity LLC is the owner of the property in Clearwater that has been liened. Now all of Veracity's properties within Pinellas County are subject to that lien as well. But the request is that we release that lien specific to the Largo property that Mr. Gallagher has purchased. And so it would only release the Largo property. If there's other properties that Veracity owns within the county, those would come under the foreclosure that we're discussing.
All right, Mr. Gallagher, you have the floor.
Yeah, this is a crazy case.
First state your name and address for the record, please.
Ryan Gallagher, 224 Melody Lane in Largo.
All right.
So I bought this house, it was a mess. I think it was last November I bought it. This house had fines, on it every single day. But I knew that with Largo. That one had, the roof blew off in the last hurricanes. I knew it was a mess. So we get the house all fixed up. I bought it for, I think it was $130,000 I bought the Largo house for. We fixed it all up. Did the lien waiver with Largo. Largo said, cool, you guys fixed everything, beautiful job. We're releasing our lien. House sells on market right away. We got a good family ready to move in. Title company says, hey, there is $200,000 in Clearwater fines on this house. And I was like, no, there's not. So my title company tracks down the title company that we bought it with, because it was the sellers came to us. I bought it through like a wholesaler agent. It was weird with how I bought it. I have all that paperwork, if you guys wanted to look at it. It was like some kind of third party. It was listed on the market. But I live on the street, wanted this house for years, got it, now I'm able to fix it. So I find out that we have all this. The title company says, oh no, Clearwater had a $660 lien on it. We fixed it, they paid it. Here's the title insurance saying that, only the Largo fines are accruing. Cool, got that fixed. And then title company comes back, I think it was Natalie. Was it Natalie that we talked to? I think it was Natalie said, hey, no, there's these $200,000 in liens still on this property. Can't close on it, can't sell it. Then I go back, beg the title company, say, hey, can you guys just give me this, give me the seller's, phone number. I never talked to the guy, I never met the guy, that owned both of these properties, just knew that he bought them and let them rot. So tracked down this guy. At the same time I was tracking down and got a hold of Jared and said, hey, what do I do here? I've never run into this. Title company's just like, well, you're not even insured up to $200,000, so you got to just figure this out. So through all that, Jared's helped me get this meeting here. I'm just asking, just release my Largo property so I can sell it. I tried talking to the guy's Rusty. I got his information, called him and said, hey, I'll buy the Clearwater property. I'll fix it. I don't mind taking on the big jobs. And he just wants nothing to do with selling it to me.
So your wholesaler agent never let you know about the lien?
No, it was weird. Like, I buy properties from wholesalers a lot, and that's not really like the issue. What this one was, and I tried the same thing even before that, living on the street. I lived down at 224. This is 207 Melody. I was like, I want this house. I have another one at 106 that we're fixing. It's a mess too. So I was trying forever. I was trying to find this guy's information. Could never find it. And it was like a wholesaler, then an agent listed it. It was kind of funky with how the paperwork ran, but I was like, I don't really care. Even this title company, I didn't know them. They were out of Orlando. I was like, I don't really care as long as I get the house. So,
Oops.
Yeah.
Yeah, that's a whoops.
Yeah, and even that, the lady's like, oh my God, I remember this, because she said I was like the 4th or 5th person in line to finally actually be able to buy this house. Like, there was a whole bunch of people with contracts on this thing that we had to clear up before I even closed on it. The lady remembered it, and it was a year. I'd never talked to the lady since. And she's like, oh yeah, I remember exactly this file. It was messy and everything. I was like,
that's why she remembered. It was
yeah.
so messy.
Mm-hmm. Yeah.
Do you think your wholesaler didn't let you know because he knew about that big lien?
No, I talked to, I can't remember her name at the title company, because I never really even took, like I said, it was on market, so I really got the agent, showed it to me, and I told him, yeah, I'll take it. And then I really basically talked to the title company after that, because I knew of the code violations, I needed to know exactly what was, you know, what I was taking on from the city of Largo. I mean, I bought it with, it was $130,000 from Largo at that point. And by the time we got it cleared up, it was like $160,000 from them. So I knew we were taking on heavy fines, but I knew I was fixing the house. So I talked to the lady out there, and she, you know, they explained everything that was going on with Largo, and then I got the letter saying that Clearwater was paid. So she just completely missed the other fines at $300 a day. Which I don't know how she did that, but.
Yeah, really.
Got
So,
lost in the
I have a question for
paperwork.
you, Jared.
Yeah.
So it's fine, as far as the city is concerned, to release this property in Largo? That's what you're saying?
Well, it's not going to impact our ability to foreclose the city's lien on the Clearwater property that was the subject of the violation.
Right.
So we will, in fact, that is in process, and assuming that the council approves that when I bring it to them, or when we bring it to them later, or early next year, if they approve that, we will be able to foreclose on the Clearwater property under the lien. This release would not impact the fine amount, so that fine amount continues to grow, and the only thing I would say is that this is, you know, it is, cross encumbrance is kind of a tool. Ideally, the title company that he hired when he purchased from Veracity would have identified the lien. That's when our leverage over Veracity would have had application to that transaction. Because they missed it, now he has the property and Veracity has the money for the Largo property. So we don't really have any leverage with the Largo property anymore.
Okay.
And so that's why I say it is a piece of leverage normally, but here in this situation, we've kind of missed the window.
Okay, thank you. Okay.
And I am still trying to buy the Clearwater property to fix that one.
Good
too.
luck.
I went by it, I have all the neighbors telling me when people are out there working on it. So I even know that he had people out there, whenever it was, last week, working on it, because they called me to try and buy it too. Because nobody likes that house.
Okay, yeah. Okay.
So,
Go ahead.
so our motion's going to be based not a partial release, but a full release for that property.
Yep.
No, it should be a partial
Still
release of the
partial.
lien, and then we have, Madam Clerk, I believe you have a document ready, right?
Yes, please.
And the document specifies the Largo property, so we are, and anything more than that, we would definitely object to, but specific to the Largo property that Mr. Gallagher has purchased, that we're not objecting to that release.
And since it's a Largo property, Clearwater has no like administrative fees on that particular property, right? It would be.
Well, we would intend to collect our administrative costs through our loan to Clearwater.
Okay, all right.
I'm ready.
And Board,
Okay, go ahead. Oh,
real quick before there's a motion, I just want to correct the record because the agenda item, there was 3 liens that the city has against the Clearwater property, and only 2 of the liens are listed on the agenda item. So,
Well, that begs a question then, in making a motion, do we actually have to dictate the recorded, or can we just give it a partial
no,
release
just,
lien on the Largo
you-
property
yeah,
as a general
just
statement?
But for the record, the 3rd lien is in OR book 22136, page 204. Thank you.
Good. Okay. You ready?
Yep, I'm ready.
All right. I move to enter an order granting a partial release of lien on the Largo property.
Did you guys need the address?
I think we have.
I defer to the attorney and the clerk on the form of the motion, but
Yeah, the property address for the Largo is 207 Melody Lane.
Yep.
If you want to include that, just.
207 Melody. Okay. All right, we'll do that then. I move to enter an order granting a partial release of lien for 207 Melody in Largo regarding the 1234 Eldred Street compliance issue.
Second.
All in favor?
Aye.
All opposed? All right, motion carries.
think on the
Thank you,
fly.
Mr. Gallagher. Ran out of breath at the end there.
Not sure, but I.
Okay, next up on our agenda is 5.2, case 88-24. Consider request by petitioner Richard Vera, CO Genuine Investment Land Trust at 1803 Sunset Drive to reduce the fine, RE landscape encroachment and sidewalk and parking surfaces, and if approved, issue an order that specifies a fine that includes administrative costs, establishes a date payable, or the lien will revert back to its original amount. We have a lien reduction application from Richard Vera. His current lien amount is $130,800. His desired lien reduction is 1% of that, $1,308.
Is he the seller or the buyer?
He
Oh,
is-
he's here.
Yes.
Hello.
Yes.
He's present.
Yeah, come on up. State your name and address for the
Good
record,
afternoon,
please,
Council.
sir.
Richard Bear for 1803 Sunset Drive.
All righty.
So are you the seller or the buyer?
Yes, I'm part of Genuine Investments. We foreclosed on the previous owner on June 9th.
Okay.
As soon as I was aware that there was this violation on the 28th, I've been in touch with Dan Kasman. He's been excellent at getting this resolved quickly. I had everything in compliance by the 3rd, along with, there was another violation that was cured a few days prior to that. And we have the property now. It's going to sell for someone that wants to build a house on it. But it took us almost a year to foreclose on this gentleman. And we're pretty much selling it at a loss. So that's where we're at. But we have a scheduled closing date within the week, but they could extend if needed.
Thank
But
you.
everything's in compliance, unless I
Good.
can do anything else.
What is our administrative cost on this?
I forgot to bring a picture with me, but it was $720.20.
$720.20?
And then, Daniel, do you remember your costs?
It was 728.
Yeah. I'm sorry, I have it not here.
Sorry. Biting my finger.
Sarah's looking it up.
That's okay. 720 plus this?
Yes, I'm looking at the calculation of costs that was prepared. It was for investigation, it was $728, based on 28 hours of investigation time.
That's $728?
Yes.
Okay.
So the total will be $1,448.20 for admin costs.
How much in the code?
1,000.
$1,448.20.
Okay.
Now, does that include the 728 or no?
Yep.
It does. All right, so
That's
that's the total that the city has in it. Okay.
720
thank you.
plus the 728.
Okay.
No, she said the 728 is included in the 1448.
Yeah.
Yeah.
Yeah, there was the 720 plus 728 gets the 14.
Oh, I got you.
Yeah.
Okay. I didn't realize you're talking two separate numbers there.
Board, what's your thoughts on this? I'm fine with administrative costs on this
Yeah.
one.
Yes.
You know, so we can get this thing sold and get the new owners in it and
But
everything.
one of the biggest indicators to me is the fact that as soon as they knew about it, they
Yeah.
took care of it, and they had to foreclose on the owner to be able to do it, and on whoever the previous owner, so.
I'm good for it,
Yeah.
Mr. Chair.
All right.
Yep.
Can I get a motion for that?
How many days?
I move to enter an order reducing the amount of the lien to administrative costs of $1,448.20, payable within 30 days.
Can I pay it today, here, while I'm here?
Payable within 30 days, or the lien will revert to its original amount.
Sure. Have a second?
Second, yeah.
All in favor?
Aye.
Aye.
All opposed? Motion carries.
If
Thank
you
you
wanted to
very
pay it
much.
earlier, the
It's been a
clerk
pleasure working with you.
Thank you. She's the one to talk
All
to.
righty,
Yep.
our next case
She takes some
is
money.
6.1 on our agenda, case 192-25, accept the nuisance. Oh, yeah, we're on this. Accept the nuisance abatement lien for respondents Creo Land One LLC at 809 Palm Bluff Street for lot clearing and issue an order of compliance and deadline and authorize the city to mitigate the violation if compliance is not met. There's no one here for that. Ms. Green, you have the floor.
Good afternoon, Board. Sarah Green, Code Compliance Supervisor for the City of Clearwater. Greg is out, so I'll be doing the next two cases for him. This is case number 192-25 for 809 Palm Bluff Street. This is a nuisance abatement. There's one violation for Code Section 3-1503, B7 and B8 for lot clearing and right-of-way maintenance. Notice violation was posted and mail was mailed on 10/10, posted on 10/27 after the notice came back unsigned with the compliance dates. This is a vacant lot that's had debris piling up on it. It's overgrown, it's got a lot of debris. And then just on the other side to the left, there's a bigger pile of debris piled on this corner of the property. This is the date of posting, it's still overgrown, still a lot of debris on the property. This is 11/10 after the compliance date. The piles of debris are growing as they tend to do when someone sees debris, more debris gets added. It's still overgrown, still debris, and then this is this morning, pile's grown, so we really need to get out there and clean it. Compliance can be met for the lot clearing by clearing all overgrowth and debris from the property. And we're requesting compliance 5 days after the board renders its order.
I have a question that, once you clean these up, do you guys like put signs out that says like no dumping or something? How do you keep people from coming back here? Oh, I know where there's a place to dump, you know?
It becomes a little tricky when it's private property, so technically we can't really post permanent signs on it's private property. That's why we try to keep these clean, try to get to them before they get worse.
Yeah.
Because once someone sees there's one tire, then suddenly there's 3, and there's 10 tires, so we try to get to it early.
So once you see this, and we sell it, but they are on your radar.
Yes, now they'll be on our radar, we'll have a board order, we could theoretically go out and continue keeping it clean.
Thank you.
Buy a used
Mr. Chair,
police car and park it on site.
Pardon?
Buy a used police car and put it on site.
I just, so you know, that the request, it is to abate and maintain. And
Oh,
so
so
once the board enters these nuisance abatement orders, we clean it up once, we will continue to go and clean it up once it becomes in violation again.
Good.
And that order remains until they pay those liens and release it.
And that keeps getting tacked on, that every time you come back to clean up, it just keeps getting tacked on to the original cleanup bill.
And it's been a while since you've seen someone challenge a subsequent abatement, but if someone were to say, oh, that, you know, we came out a second time or a third time and we shouldn't have, we would just bring that to the board and you guys would decide whether or not we should have or shouldn't have come out a second or third time.
Thank you, Counselor, that's good to know.
It is.
Board, do you have any
There's
questions
latitude.
Page
Finishes the admin on it. That's
I
great.
think so.
Or the repeat.
Yeah.
All right, can I get a motion on this? If no one has any more questions for Ms.
Somebody
Green.
go.
Ready?
Sure.
I move to enter an order finding the respondent in violation of code and requiring the respondent to correct the violations within 5 days of the board's written order. If the respondent does not comply within the time specified, the city may take all reasonable actions, including entry onto the property to abate and maintain the nuisance and charge the respondent with reasonable costs, which will become a lien on the property. If costs, fines, and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor?
Aye.
All opposed? All right, motion carried. Next is 6.2 on our agenda, case 193-25, accept the nuisance abatement lien for respondents Jolanta Wasowski and Mirosla Wasowski at 915 Seminole Street for lot clearing and issue an order with compliance deadline, authorize the city to mitigate the violation if compliance is not met. No one's here. Ms. Green.
All right, good afternoon, Board. Sarah Green, Code Compliance Supervisor for the City of Clearwater. This is case number 193-25 for 915 Seminole Street, another nuisance abatement. There's one violation here for lot clearing for debris. Notice of violation was posted and mailed on 11/6 with a compliance date of 11/11. This was a move-out from rental property. All their belongings were put out to the curb. Ordinarily speaking, what happens in a situation like this, a landlord would notify solid waste beforehand that a move out was happening, and they would plan to come and pick it up. Even after the fact, that normally happens. However, their utilities and water are shut off, so solid waste has no mechanism to charge for the pickup. So now it comes to us to post it and get it removed. So this is on the date of inspection, 11/6. It's the date we posted it. It's all down the street at the curb, a lot of belongings, mattresses, furniture, etc.
Looks like people's gone through it too. As they
Yeah,
walk
it
by,
gets
so
picked
it
over.
gets all strung out.
This is after the compliance date. You see the pile's gotten bigger. Like I said before, when one piece of debris ends up on a property, more tends to follow, so the pile is getting bigger, so we like to get out there and take care of it. After the compliance date, and then this morning, the pile of debris is still there, so we like to go out and take care of it. Compliance can be met for lot clearing by clearing all debris from the property, and we're requesting compliance 5 days after the board renders its order.
Inspector, I have just one question. Whenever somebody puts that much out on the street, or any amount of trash like that, are they responsible, is the city responsible for picking it up and charging as well?
It would depend on the situation. Like if you have trash service and you put out large debris, solid waste will come and pick it up, or you can get time charged for a large bulk pickup. For, like I said, if it was in the case of a move out, the landlord can schedule, hey, my tenant's moving out and they're planning on putting everything out at the curb. Please have solid waste notified to come and plan to pick it up then, and it would get charged the water bill. In this case, services are off, so solid waste has no mechanism to charge someone for it. So therefore, we're the mechanism at this point.
Okay, thank you.
Any more questions for Ms. King? Can I get a motion?
I move to enter an order finding the respondent in violation of code and requiring the respondent to correct the violations within 5 days of the board's written order. If the respondent does not comply within the time specified, the city may take all reasonable actions, including entry onto the property, to abate and maintain the nuisance and charge the respondent with reasonable costs, which will become a lien on the property. If costs, fines, and fees remain unpaid for 3 months, after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
I'll second it.
All in favor?
Aye.
All opposed? Motion carries.
Thank you, Ward.
Next is 6.3 on our agenda, case 194. Accept the nuisance abatement lien for respondents Jessica and Lawrence Ford at 1586 Linwood Drive for lot clearing and issue an order with compliance deadline and authorize the city to mitigate the violation if compliance is not met. Inspector Castman, you have the floor.
Good afternoon again, Board. Daniel Kasman, Code Inspector for the City of Clearwater. This is 1586 Linwood Street. It's a nuisance abatement, case number 194-25. There's one violation here for Code Section 3-1503B7B8 for lot clearing. These are the dates the notice of violation went out with the compliance date and the affidavit of posting. This is 1586 Linwood Drive. The grass is getting pretty long over there. This is the date of the posting on the 30th of October. In addition, the lawn is also taking over the sidewalk. This was after compliance date on the 13th. Lawn's in the same shape. And then this was today. All right, so compliance met for lot clearing by mowing the lawn and edging the curb and sidewalk. And I'm requesting compliance on it before 5 days from the date the board renders its order.
All right. Any questions, Board?
Is it occupied?
No, it doesn't seem that there's anybody there.
Do we know where the owners are?
I really don't know. No, it's kind of perplexing. It's a house and just nobody mows the lawn. I tried calling, I left the letters, nobody signed for anything, and that's how it's been.
All right. No more questions, Board? All right, may I get a motion?
I move to enter an order finding the respondent in violation of code and requiring the respondent to correct the violations within 5 days of the board's written order. If the respondent does not comply within the time specified, the city may take all reasonable actions, including entry onto the property, to abate and maintain the nuisance and charge the respondent with the reasonable costs which will become a lien on the property. If costs, fines, and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor?
Aye.
All opposed? Motion carries. All right, next is 6.4 on our agenda, case number 195-25, accept the nuisance abatement lien for respondents Noel Allen and Cleo Allen at 1943 Nugget Drive for inoperable vehicle and issue an order with the compliance deadline to authorize the city to mitigate the violation if compliance is not met. Inspector Casper.
All right, good afternoon, Board. Daniel Casman, Code Enforcement Inspector for the City of Clearwater. This is case number 195-25 for 1943 Nugget Drive. It's a nuisance abatement. There's one violation here for Code Section 3-1503B6 for an operative vehicle. These are the dates and notice of violation out with the affidavit of posting. This was back in September. I had previously spoken with the owner. This came as a complaint from a citizen about this Dodge Caravan that's sitting there in the driveway with an expired tag. He said he was calling up the junk company to come by and haul the car away. I gave him a month and nothing happened. I gave him 2 more weeks and he didn't do anything with it, so I had to finally post the vehicle. This was on November 4th when it was posted. Here's a picture of the posting. And then this was today. I have still been speaking with both of them, and both the wife and the husband there at the home. And I said, you know, just need to get rid of it or register it, and they assured me they will do it, but they continue not to. So, compliance can be met by displaying a license plate with current tag on the vehicle or by removing the vehicle from the premises. And I'm requesting compliance on it before 5 days from the date the board renders its order.
All right. Any questions, Board? Nope. Can I get a motion?
I move to enter an order finding the respondent in violation of code and requiring the respondent to correct the violations within 5 days of the board's written order. If the respondent does not comply within the time specified, the city may take all reasonable actions, including entry onto the property, to abate and maintain the nuisance and charge the respondent with the reasonable costs which will become a lien on the property. If costs, fines, and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor?
Aye.
All opposed? Motion carries.
Thank you very
All
much.
right, next is 6.5 on our agenda, case 196-25. Accepts the nuisance abatement lien for respondents Greg 16 LLC at 721 Mandalay Avenue for lot clearing and issue an order with a compliance deadline and authorize the city to mitigate the violation if compliance is not met. Inspector Maddox, you have the floor.
Good afternoon, Board. Kevin Maddox, Code Compliance Inspector. This is case number 196-25 for 721 Mandalay Avenue nuisance abatement. One violation, Code Section 3-1503B7, B8, and B5A. Overgrowth right-of-way, and accumulation of debris and trash. This is the date, so the notice of the violation was mailed and posted. Compliance date and certified mail was not received back, but it was posted. This is the lot. It's like any other lot that got a house demolished and then left. But in the areas out by the islands, there's a whole lot of these now. And I'm holding them all in compliance to keep their lawns and grass and everything trimmed up. This is the posting date on October 27th. It's getting very long. This is November 10th, and it remains the same. And this was today, this morning, and it remains the same. Compliance can be met for lot clearing by cutting all grass vegetation, including the curb line, sidewalk, and continuing to maintain it, removing all trash and debris, and continuing to keep it clean. For 196-25, requesting compliance 5 days after the board renders its order.
All right. Any questions, Board? No? Can I get a motion?
I move to enter an order finding the respondent in violation of code and requiring the respondent to correct the violations within 5 days of the board's written order. If the respondent does not comply within the time specified, the city may take all reasonable actions, including entry onto the property, to abate and maintain the nuisance and charge the respondent with the reasonable costs which will become a lien on the property. If costs, fines, and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor?
Aye.
All opposed? Motion carries. And Board, if there's nothing else before us, we will adjourn.